SJC-12279, Commonwealth v. Julie Eldred.
Ms. Newman-Polk, good morning.
Good morning.
You bring quite a crowd with you.
Good morning, and may it please the court. My name is Lisa Newman-Polk, and I represent Julie Eldred, who suffers from a severe substance use disorder and was jailed for 10 days for exhibiting a symptom of her disease. Today, we ask this court to apply the legal standards already set forth in Henry and Canadian to the context of probationers who are diagnosed with a substance use disorder as defined in the Diagnostic and Statistical Manual of Mental Disorders. For the person who suffers from a substance use disorder, a court order to be drug-free is effectively a court order to be in remission of one's addiction.
Let me ask you a question. There are really two things here going on, right? You're asking us to say that it's not all right to impose a condition of probation that says that you must remain drug-free, and you're also saying that in the event that a condition like that has been imposed, it's not permissible to find a violation on that basis because there is no capacity for willful violation of it in somebody who has been diagnosed with SUD.
Yes,
SUD.
for somebody who's been diagnosed with a substance use disorder. So in the case of Ms. Eldred, because the condition was already set, our argument is that she is not to be found in violation because the allegation of the behavior was not willful. Our suggestion to the court is that in the future, an analysis should be done following the instructions of Henry as to whether somebody has a substance use disorder, meets criteria for that, and if that is the case, the condition lawfully and under good court policy would be to be in mandated treatment, to engage in treatment.
Yeah, let me ask you about that. So what conditions can be imposed? Can you impose a condition of continuing, you must remain in order to avoid incarceration, because if you assume that incarceration can be a result, can be a possible sentence for a crime that was committed here. It was
Yes.
because she stole jewelry from a dog walking client, right? She admitted to sufficient facts as to that.
Correct.
In order to support her drug crime, her drug use, apparently. But in any event, so one of the conditions of probation is ordinarily don't commit any more crimes. Another one of them could be you must participate in treatment. Now, I guess what you're saying is as a result of the disease, assuming your view of the science is correct, that it is always and everywhere the case that somebody who has that diagnosis would not have the self-control to resist the urge to use drugs. Now, if somebody didn't have the didn't have the ability to resist the urge to use drugs, how is it that she could resist the urge to commit other petty crimes in order to support her drug habit? How is it that she could have the self-control to continue in a treatment program that presumably does not want her to use drugs?
So, Your Honor, the diagnosis being that it's a chronic relapsing condition is how substance use disorder is defined. The issue where the control has been damaged, so to speak, that a person's brain has been rewired in such a way that it makes it very difficult to exert control over the compulsion to use, is very specific to the drug use. That is not, however, the diagnosis, however, is not that somebody goes and commits crime.
No, but in order to support the drug use, I mean, you have the urge to use the drugs. You don't have the finances to do it. You need the money. How can you not be then urging urged to do anything to get the drugs, including committing the petty crimes?
Well, Your Honor, we're not arguing criminal responsibility, and we're...
No, I'm trying to figure out what it is you are arguing. What is the extent of the lack of control?
The extent of the lack of the control is that we're focused on what that diagnosis actually is, which is not a compulsion to commit crime.
No, it's a compulsion to use the drugs. I understand
Right.
that, but the compulsion to use the drugs carries with it certain other things, like staying in a treatment program.
Correct. And so I think a part of a way to answer that is that there is this concept that somebody needs to be in so much pain in order to get better from addiction. That's sort of an idea out there. I think a better way of looking at that is accurate is that when somebody is feeling so sick, it can be a time and a transition period to actually try and get help. The issue is once somebody is going in and can make that choice to go get the help, as Julie Eldred did, and the court is ordering it, and she is following through with going ahead and getting that help. The issue is around if the disease, as it's out there from the Surgeon General, NIDA, the World Health Organization, et cetera, is that there's this compulsion to use. When triggered to that, that is something that can be very difficult, albeit obviously not totally impossible, because at some point people eventually recover, but the point of the treatment is going to treatment and learning and gaining those skills in order to stop that compulsion.
Ms. Newman-Polk, are we skipping a huge step here? Everything you've been saying hasn't been tested through the crucible of litigation. We've got no record here as it relates to the relationship between the brain disease and motivation. Don't we need some sort of a record before we say that somebody can't comply with a condition of probation?
Well, Your Honor, we do have a record from Dr. Sarah Wakeman, who's the medical director of the Substance Use Disorder Initiative at Mass General Hospital. She filed a 9-page affidavit at the trial court level.
Affidavit is different than something being tested in litigation in court, isn't it? She wasn't subjected to cross-examination. There were no counter-experts. There were no arguments, no findings.
So the Commonwealth did not put on any evidence in response to that. But I think this is an area where this court in the past has recognized consensus science.
Right.
And the consensus science that we're presenting, we're not presenting something controversial much to what the Commonwealth is saying.
Well, let me ask you a different kind of question with regard to other kinds of things. Suppose we accept your position and say that that's the right way to go. Organic brain injuries sometimes lead to something called explosive disorder or violence. If we held as you wish, would not your case then apply to somebody who was on probation for committing a violent crime like an assault and battery, who had a defense of organic brain disorder, and then while on probation committed another violent offense?
I haven't looked at the actual diagnostic criteria for that specific disorder, so I can't speak to exactly what that says. I don't know that it says in there that part of the diagnosis is that people commit crimes such as assaulting people. Very specifically, the criteria in substance use disorder is in fact this thing that's being ordered to not exist anymore. What is not in the criteria is not saying, the criteria does not say people commit crime.
One more question. What about the defendants who want to say yes to that probation condition?
To be drug-free and test?
To test, and
Yes.
who say, because obviously if you remove it completely as a potential condition, it affects people who would have chosen that rather than serve a term of incarceration and have to suffer withdrawal symptoms without the traditional supports that they would expect in some other setting. So what about the people who would say, I would like to go through the probation process and be drug-free, I need that incentive?
I think that if somebody presents to the court, well, first of all, let me just back up for a second. Treatment programs, as a general matter, are going to do drug testing. So, and a condition to be in compliance is that the provider would be given the permission to be able to communicate with the probation department as to how that person's progress is going. Is the person engaged? Are they showing up? In terms of somebody who suffers from substance use disorder and says, I want the threat of incarceration, I would be surprised that that's something somebody wishes. However, I do think that it should be very clear that this condition does not apply to somebody who does not have a substance use disorder, but maybe has engaged in a crime that was sparked by some sort of substance use. And that is where the evidence is clear that incentives to not use can be done with a threat of incarceration. And I'd like to take the opportunity to note that the National Association of Drug Court Professionals brief to this court misconstrues what is stated in the Surgeon General's report. The Surgeon General says that with regard to people who do not suffer from a substance use disorder, the threat of incarceration can be a powerful incentive. And of course, that makes sense, because if it is something that we absolutely have control over, it may be inconvenient and somebody doesn't want it, but they don't have the compulsion that meets the level of criteria.
Yeah, can I ask you about the options you present to us? You said that, so someone is diagnosed with SUD, and you said one of the options would be for mandated treatment. That's a legitimate condition of probation, correct?
Correct, yes.
So someone has mandated treatment. Under your view, they walk away from the treatment facility because they don't want to, they're not ready for treatment because of the nature of the SUD. Can that person be in violation of probation and be incarcerated?
Yes, absolutely.
So what about if there's also, what conditions are you saying are okay to impose, assuming that the judge knows that the person has SUD, which is itself a question about how you do that, but even if you assume that the judge imposing a probation condition or a series of probation conditions knows that the person in front of him has or her has SUD, you've said mandatory treatment, you've said drug screens, random drug screens are okay.
Sure,
The condition of no further crimes.
sure, yes.
Anything else is okay? The only thing that's, the
yeah,
only thing that's not okay, basically, is the one that you're objecting to?
The one thing we're objecting to is the criminalization of relapse, which...
No, you're just objecting to the fact that there is a condition that's imposed that says you must remain drug-free.
Correct, which in effect for this particular population, like Ms. Eldred, is an order to be in remission or cured of the illness.
And what's the point of drug testing?
That is if the court wants to have some sort of monitoring. They want to test it just to see that they're having some sort of oversight. So, for example, somebody is in treatment and the court wants to be able to, the probation department wants to know how their progress is going for themselves. I'm not saying it's necessary because I think this could be done through programs. However, that would also, if testing was allowed, it could allow for, of course, testing to be provided from the providers to the court. It allows an open chain of dialogue between a probation officer and the treatment program in terms of how the person is doing. I'm not saying it's necessary, but I'm just saying it's not illegal.
Okay,
Without
here, what we
consequence,
have...
Yes.
I'm sorry, what we have here is a situation where she is put on probation with these conditions. She goes in after having started with the treatment center, but when she goes to see her probation officer shortly after that, the probation officer has her do a drug screen, and she comes up with fentanyl as well as with Suboxone, which is okay.
Prescribed.
But the fentanyl in her bloodstreams, even if, so what happens next is that the probation officer goes to the court and says, look, this is what happens. If you didn't have the no drug condition, and you simply had the drug screen condition, could the judge do what she or he did at that point, which was to say, okay, look it, it's Labor Day weekend, you have fentanyl in your system, fentanyl's a dangerous drug. I'm going to change the conditions of probation not to include not just treatment, but inpatient treatment. Could the judge do that?
I think that that would be perfectly reasonable if there is consultation with providers who are making an assessment as to what the proper clinical treatment is, so that judges are not making decisions for probationers. There's communication with these specialists in the field as to what the appropriate treatment is.
So what's the point then, I think is what Justice Gaziano was asking, of having the random drug screens? You know, you say open communication. What's the judge supposed to do then? You have somebody who has screened in positive for fentanyl, a very dangerous drug, and the judge knows that the only probation condition relating to treatment is just treatment, and wants to, can the judge modify the treatment condition at that point and say it must be inpatient treatment?
I think that the way that this works in the best manner is if, and this stands actually right now, that when people are in treatment, usually the order is to comply with treatment. There's some level, comply with treatment laid out in an assessment by a provider. So The only reason that maybe that drug test serves some purpose is if a probation officer wants to open up that dialogue with the provider, Dr. O'Connor, who Ms. Eldred had just seen 2 days earlier, the provider she had been working with, to call and say, I'm concerned, I noticed that this did come up positive, can you give me more information? Do you think she's okay? Do you think that maybe I should Section 35 her? What are your thoughts? Because if the real issue here had been safety, if this had been for her safety, and I'm actually not disputing that per se, what I'm saying is I think that's a wrong reason to incarcerate somebody. The appropriate thing to have done would have been to have filed a Section 35, which a probation officer could have done, to have had a court clinician come in and assess her, which would have involved a process of an evaluation, talking to her family members, calling providers to see if they could get them on the phone, and having a professional.
Aren't you, you're proposing a categorical rule, right? Anyone with a substance disorder we can't violate probation on this ground. Anyone, not just your client, the world, right? And that's not individualized. It's based on 2 affidavits that have been submitted that we're going to make that kind of rule.
I think it's based on more than that, Your Honor, because there are amicus briefs in this case, and one from the Massachusetts Medical Society presenting the consensus science.
Having read I can't tell whether they're creating a categorical rule or you're arguing for a categorical rule. I clearly understand that people think it's better not to do this in most circumstances or generally, but you're proposing a categorical rule for everybody that we don't do this.
And the reason for that is, and I think it's a mind shift for us as a culture and a society, but this is a disease. It's recognized as one by everyone in our public policy sector. And so there's this last piece that we need to have the courts catch up with and recognize that a symptom of a disease is not something that can be ordered away. And I do want to emphasize that treatment is not easy to do, as it's been suggested. If somebody walks away, they could be incarcerated. There could be a hearing in terms of, is somebody in compliance with treatment? And if it's deemed they're not in compliance, they still could have the threat of incarceration. The issue is allowing people to work their process.
What if somebody has a conviction for operating under the influence, 8th offense, and there's a split sentence or from and after probation? Can there be a condition of no use of alcohol?
Well, the first assessment would be, is there an alcohol use disorder that meets criteria? Sounds like with an 8th offense that's probably the case. Under my suggestion here, no. However, there could certainly be a rule around not driving. That person's not going to have their license anyway. And treatment is really what we want people to be mandated to do and coerced into doing. And NIDA, by the way, in their suggestions, they are saying that coercion into treatment by the court system is an effective thing to do. But I want to be clear, they're not saying, they're very clear that if there is a problem with treatment or relapse occurs, that the response should be treatment.
But when you have somebody who's got an alcohol addiction and they're making a judgment about whether or not to get in the car, they're impaired. When somebody needs opiates, it's hard to make a rational decision about whether or not you're going to steal when you're feeling that level of pain. There's a public safety aspect of this as well.
Well, I understand that, but the thing is that ordering it does not make it go away, right? So even though a court can order somebody who's had an 8th offense with alcohol and suffers from severe alcohol use disorder not to drink, very, very often, I mean, if that person has a severe alcohol use disorder, which is likely in that scenario, just ordering it to stop is not going to make it stop. So the issue is getting that person into an appropriate level of treatment and saying, we are holding this stick over your head for you to be in treatment. And the assessment we've gotten from these specialists is that it needs to be 9 months of inpatient, et cetera, or residential, et cetera.
Can I ask you a question, a slightly different question, which is that it seems to me that the experience has also been that there are any number of people who have been able to comply with the condition.
So,
And does that mean that those people don't have SUD?
yes, again, pointing to that Surgeon General report, which is Chapter 4, page 40, they talk about on there that, for example, the HOPE program has shown that it can be a powerful incentive to have the threat of incarceration over someone. And then they make a very specific note to say, This tells us the HOPE program does not only have people with substance use disorder in that program. So,
So you're saying that the people who can avoid the drug use and comply with the condition don't have SUD by definition?
I'm saying correct with just a little follow-up, which is the definition of this disorder is continued use of substances despite negative consequences, even jail or prison. So if somebody is able to just stop using like that without any help or any assistance.
No, suppose they get assistance, but they're able to do it.
Well, if they're able to get assistance and able to do it, that's...
Don't have SUD, you're saying?
No. I'm not per se saying that, but I am saying that statistically speaking, somebody who meets criteria for this disorder, statistically speaking, is going to have some bumps along the way. And it's a better public health policy to be mandating that person into treatment and continuing rather than to disrupt it by putting somebody in jail.
So you define SUD as someone who violates probation?
That's not the definition. I define it by what the DSM says for it.
Well, it seems to me you're being very selective. If you said, if you look at Hope More and all the work they've done, and then you say, well, discount those people because they really don't have SUD. That seems to me to be a little bit like cherry picking.
No, I'm not saying that, Your Honor. That's actually what the Surgeon General says about the HOPE program, that it's clear that there are people in that program who don't actually have SUD, and the people in that program who are violating the condition are then moved into treatment.
Let me step back, moved from the macro to the micro. Regardless of whether there's a condition of probation to not use opiates, it's a crime. So when the probation officer discovers that she had used fentanyl, the probation officer had recognized that she had committed a crime, or arguably had committed a crime. So probation officer, there's always a condition of probation, you may not commit crimes. Is it wrong then for the probation officer to notify the judge that it appears that she has violated the condition of not only to not use drugs, but also to commit no crimes?
Well, Ms. Eldred was not charged with possession, and under the Pellegrini case, there is an indication that a urine analysis would not be enough to, it might be enough to charge for probable cause, but not enough to convict.
Okay, but it might be enough to permit a judge by preponderance of the evidence to find that there's been a violation of probation, which is all that the judge need find.
I mean, I have to concede that, obviously, Your Honor, but I still think that my argument stands in terms of...
Well, I'm trying to figure out what your argument precisely is. I mean, let's look at it from the point of view of each person doing their job. So the probation officer has her obligations to do drug testing, comes out positive for fentanyl, which we know has been the source of many, many, many deaths in this Commonwealth. Was it wrong for her to go to the judge and say there appears to have been a violation of probation?
Well, I don't think it was wrong under the current set of circumstances in terms of...
In your world, and what you are asking us to say the world should be, what should that probation officer do under those circumstances?
I don't think that it is a willful violation. That is the argument. It's not a willful violation. There has not been a new crime charged. And I just do want to point out, because I know the time is short, that people who are in jail are at 120 times the risk of an overdose death in this state.
I understand that. I'm just trying to look at it from the point of view of each person doing their job. Mm-hmm. So probation, I mean, you can argue it's not a willful violation, but isn't that a matter to be decided ultimately by a judge based on evidence presented by both sides as to whether or not it was willful? Is that the probation officer's job to say it was not willful?
I do think it's a matter of us being able to present the evidence in this particular incident, which is what we did. She had already had the condition, so we're in a Canadian scenario here, where after this violation has been alleged, we presented a whole host of...
Okay, but you're not answering my question. The question I'm asking you is, was it appropriate for the probation officer to notify the judge that she appears to be in violation both of law and of a condition of her probation?
I think what I'm confused by with the question is, was it inappropriate under what was set no, but I do think that it is unlawful to
Okay,
have
so I
that
mean,
condition.
so if you, I mean, so in the world that you want the probation officer to not notify the judge? Is that what you want?
In the world that I want, if the probation officer is concerned for safety, I want that probation officer to file a Section 35.
Can't they do that now?
They can. That could have been done here if that was the issue of
And,
safety.
but it still was and to ignore the fact that there was a violation of the condition and of arguable violation of law? To basically go to the court and say, I seek a Section 35, and not to notify the judge?
Well, under the
So under these circumstances, I mean, if you had prevailed in the Section 35, she would be ordered civilly committed for longer than she actually was committed. She was committed for 10 days until a bed came free. It would have been longer if they had gotten a Section 35.
That is true, but the Women's Addiction Treatment Center is quite different from going to Framingham and being strip searched and degraded.
But I mean, the judge's ruling, I gather, was simply, I gather from the record, it appears the judge would have put her in inpatient treatment if he had that option. The problem is that there were no beds.
Well, we were not given an opportunity to call a detox, to make any efforts towards that.
Counsel, why is this a matter for the court and not the legislature?
Because I think under Henry and Canadian, it's not a willful violation, and therefore it falls into that framework.
Okay, thank you.
Thank you.
Ms. Granick, good morning.
Good morning. May it please the court. Assistant Attorney General Maria Granick on behalf of the Commonwealth. I would like to begin by pointing out a few of the things that the parties agree on in this case. There's no dispute that addiction is a disease, or that incarceration alone does not help address addiction, or that a therapeutic approach to addiction is essential. The parties disagree, of course, on whether or not substance-free conditions of probation are permissible and effective. It is the Commonwealth's position that these conditions, when used appropriately, can help reduce incarceration rates, promote recovery, and help achieve the primary goals of probation, which are rehabilitation and public safety.
Okay, well, that sounds nice, but what does it mean in practice? So, okay, so let's go back to this particular instance. Probation officer reports, I assume you believe that was the appropriate thing to do.
Yes, Your Honor.
Do you agree that the defense at a probation violation hearing could present as a defense that it was not a willful violation?
I don't think so. I don't think that this court's decision in Henry would control, and I think there are a few important...
Why would this violation not need to be willful while the inability to pay restitution would need to be willful?
I think that there are a few important differences between these types of violation. And I think one of them is the fact that the incentives to raise this as a defense are very different. So in this case, as I mentioned in the brief, it was possible for a probation or defendant to raise this kind of issue at sentencing. And
No, that would be as to whether or not the condition should be imposed in the first place. Not having
Correct.
done that, why is that waived, which is essentially what you're saying, by saying, okay, I thought I could at the time, but I turned out to be wrong. And now I know that it's part of my disease. And listen, I've got all this stuff about this is my disease and I can't do it. It's a different thing to question, because the Commonwealth has the burden of showing that it was a willful violation, right?
I think the Commonwealth has the burden of showing by a preponderance of the evidence
That it was willful.
that it was a violation.
That it was
and then,
willful. In order to be a violation, it has to be willful, right?
I think the probationer can then show that the violation, even though it occurred, was not willful. And I would argue that in this case, the probationer didn't meet that burden.
But she put in evidence saying that she couldn't help herself.
I think that the evidence...
And it was unrebutted evidence.
The evidence, Most of the evidence, including the affidavits, really supported the idea that drug use was a symptom of her disorder. There wasn't any specific showing necessarily, nor is there a clear objective measure of an ability to comply in this case the way that there is in cases when what's at issue is the inability to pay. So I think.
So you discount the affidavits that were unrebutted, that were submitted by experts in the field, that she did not have the ability to remain drug-free?
No, but I think that the judge, looking at those affidavits, could have concluded that they don't prove that this particular instance of drug use by Ms. Eldred in this case was involuntary. That
Well,
there
you
really
say
isn't-
in your brief that your position is that with this type of a brain disease, motivation still has an impact.
Yes, and I think that's demonstrated in a variety of diversion programs in the criminal justice system, including drug courts, for example. They're based on evidence-based best principles and the idea that sanctions and rewards can have an impact on behavior. And it's a precondition for participation in drug court that a person has substance use disorder. And there's a lot of research that's accepted both by experts on the spectrum of their views about the nature of addiction, that these types of approaches work.
So is that your recommended solution, the one proposed in the drug court amicus, which is that your courts are free to engage in sort of escalating penalties, and they've got to take in new science into account, and that's the way we should continue to do this? Is that essentially your position then?
Yes, I would say that I would urge the court to adopt a rule that allows the use of substance-free conditions as long as they're reasonably related to the main goals of probation. So I think, you could have a
Yeah, but
situation.
again, from what I understand, the amicus brief for the drug court says that at some point you can impose prison if there's non-compliance based on an individualized inquiry and taking into account the latest science, right?
Yeah, that's correct. And I think also it's important to distinguish this case from situations where sanctions are imposed for drug use, because in this case, Ms. Eldred's probation actually was not revoked.
This is an abuse of discretion issue, right?
Correct.
That would be the review. So if a judge was unwilling to accept this latest science, the judge could, as a fact finder, say, I just don't credit it, and there'd be no abuse of discretion? So the judge could incarcerate at will?
No, if I understand the question correctly, I think the judge would have to take into account evidence about the nature of the violation. And I think in this case, the judge did take into account the evidence and consequently didn't find Ms. Eldred to be in violation of, did find her in violation but did not revoke probation.
But unless we say something, a judge would have the ability to weigh facts as he or she sees fit, correct? And to weigh credibility of experts and to decide what they believe or disbelieve, right?
Yes.
Now we're on an abuse of discretion standard for violation of probation.
Yes.
So what guidance do we give the judges in the Commonwealth? Unless we say something, what guidance are we going to give?
I mean, I think the guidance would embrace the kind of discretion and flexibility that already exists in terms of crafting probation conditions that are reasonably related to the crime and to the person who committed the crime. In this case, it was determined that the crime of larceny was related to the drug use. It was admitted by the defendant in this case. And there was no specific showing that her inability to comply was truly involuntary. And I think under those circumstances, it was reasonable for the judge to find her in violation, but at the same time use her discretion to respond to that violation by modifying conditions and requiring inpatient treatment.
But having found Ms. Eldred in violation, the judge had the authority to say, I'm going to impose the sentence of 2.5 years in jail for the underlying crime. If the judge had done that as a result of the violation of probation, would your view be that that was a lawful thing to do for a violation of probation here?
I think that's not, these are not the circumstances of the case.
I
and that's not
understand that the
case
judge here
but I-
acted perfectly sensibly. This is not really, the judge here put her back on probation and put her in inpatient. But the fact of the matter is, a violation of probation means that the suspended sentence may be imposed, and if there's no suspended sentence, the person may be sentenced to the maximum sentence for the underlying crime. So what you need to come to grips with, and I don't hear it, frankly, is it appropriate for a judge under these circumstances, recognizing that relapse is something that routinely occurs in these circumstances, to impose a 2.5-year sentence in the House of Correction for her violation of probation?
I think that it would certainly be unwise and would not.
Is it unlawful?
Whether it rises to a level of a constitutional violation, in all cases of substance use disorder, I don't think that we could go that far. I think in some cases, if there's evidence that the person's violation truly had no voluntary basis.
There's no
then it may
voluntary
be
basis, then
appropriate.
I assume your position is that she should not be found in violation of probation, correct?
I think there may be circumstances in which that could be the case, but
Okay,
with the caveat.
Well, again, I mean, we need to, this is a really challenging issue, and each side needs to come to grips with it, because judges have to do this each and every day. So I'm trying to understand what you think the law should be. I gather you think the law should be that the judge makes a determination of whether the person is in violation, that we're not going to say that SUD means it's per se unwillful, but that each individual can present evidence to the judge, and the judge can make an individualized determination of whether it was a willful violation. Do you agree with that?
I think that could be done. I think, if we step back to,
Okay, it's really a yes or a no.
I think if such a showing were possible, which, again, I think there's questions about that, whether the specific involuntariness showing is possible, but if it were, then yes.
Let
If you
me ask
can't
you a
find that
question.
it's involuntary, then how do you find it's willful? If you can't say that someone with SUD did this voluntarily, how can it be a violation of probation? How is it willful?
If it were to, I guess my point is, if it were possible to show that it's involuntary.
So you're saying it's not
Then-
possible to say one way or the other?
I think that specific point, whether the particular instance of drug use is or is not involuntary, is not something that can be determined with any kind of scientific or medical certainty in this context.
Does a violation of probation that isn't based on a non-criminal condition, but is a general intent crime, does it have to be willful? So if someone has an OUI 8th and goes out and allegedly kills somebody, and there's a motor vehicle homicide, and they've got a straight probationary sentence, and it's a general intent crime, do we have to have a hearing on whether it was willful?
No, we do not.
Can I ask a follow-up to the Chief Justice's question? So he asks, is it an abuse of discretion to impose the 2.5 years? Could what the judge did here, what Judge Singh did here, which is imposed 10 days, or I can't remember the other judge who imposed 10 days, could that have been not an abuse of discretion, but violating and imposing the suspended sentence of 2.5 years been an abuse of discretion? So could what she have done been proper, and imposing the 2.5 year sentence not be?
Yes, I think it
And
could. I
if
think you
so,
could make
why?
a distinction. I mean, I think you could make a distinction, certainly on policy grounds, in terms of,
How about law?
I mean, I think that the position that the rule that the probationer is proposing is inconsistent in that a sentence of incarceration imposed at the beginning for the crime of larceny would presumably not be unconstitutional, but at the same time, and that sentence would carry with it forced abstinence, whereas a sentence of probation with a condition of abstinence is unlawful. I think that that's a difficult distinction to make.
I just would try to get an answer to the Chief's question, because each side's proposing sort of all or nothing solutions, but except for at least the amicus brief for the drug courts talks about escalating penalties, but I'm wondering whether that's barred by what the Chief Justice asked you, which is, if we okay what happened here, do we have to okay, imposing the suspended sentence, or can you have it both ways?
I think you can, because I think you could rely on this idea that the conditions of probation have to be related to its main goals, which are rehabilitation and public safety. And so you have to have a case-by-case determination of what kind of condition is appropriate and what constitutes a violation.
Okay, if you could do that, let me see, here's the question. I'm not really understanding why it is that the condition of probation of remaining drug-free is necessary or appropriate in light of a diagnosis of SUD, where you know that relapse is a symptom of the disease. When counsel has acknowledged that you can also have as conditions that would be carrot and stick type conditions, which is you must remain in treatment, and the judge can specify what kind of treatment. You must do random drug screens. You must not commit other crimes. Why wouldn't those be adequate to doing everything that is necessary in terms of both protecting the public and furthering rehabilitation? Why do you need the condition of remain drug-free if you know that in most instances of people with SUD, that's going to doom them to failure?
I think there are two main reasons. One is they allow for the kind of court supervision.
Well, why
that's
couldn't you
necessary that
have,
treatment
why
conditions
is there
would
court
not.
supervision necessary if the probation officer could do what she did here, which is to just go to the court and say, she's using fentanyl?
But if the only condition were to be drug tested without any ability
You
to
have to
impose
remain,
consequences.
you can't commit other crimes.
Well, that rule, that's correct, but I think that rule would be problematic in alcohol-free conditions, for example, where, uses, that requirement is still important, and the supervision is important, but the use is not illegal.
Do we have the
itself.
same kind of evidence about alcoholism as we do about SUD?
Yes, it's the same type of disorder with a different substance,
Okay.
according to the DSM.
Do you think there's a problem? Do you concede that there's a problem with the way the revolving door that we have in the opioid crisis in the Commonwealth?
Yes, absolutely. I just don't think that this, taking away the ability of judges to set drug-free conditions and substance-free conditions would contribute to solving the problem. I think actually quite to the contrary, could increase incarceration rates because, as I said before, the probationer is not contesting that you could incarcerate a person with a substance use disorder for committing the crime of larceny.
But you want us to hold in your favor and to not delineate some type of consequences of relapse to give guidance to the trial judges?
I think it would be difficult to give guidance as a matter of general constitutional principle in this case. I think.
Putting that, say you win on Eighth Amendment grounds and state constitutional grounds, you don't think that we should use our superintendent's authority to delineate the consequences of relapse in this situation?
I don't think that that could be done because of the importance of the individual assessment and the case-by-case approach to whether or not a particular instance of drug use by a particular person was in fact voluntary. And I think that's where the fact that the science is evolving in terms of our understanding of what it means to say that addiction is a disease, and at the same time recognize that sanctions and rewards do help many people recover. I think that would be difficult to establish a general principle like that.
Well, of course, it depends on your view of the science that carrot and stick actually works.
I mean, I think, again, that I'm not taking a position on the science here, but I think there's a lot of evidence that's not contested by any of the experts that programs like drug courts, for example, that use and rely on supervision and the use of rewards and sanctions do work for many people.
In the face of somebody who comes in with evidence that she suffers from substance abuse disorder, and that one of the symptoms of this is the relapsing segment, which she's pretty much powerless to do anything about. How, in the face of that, can a judge say there is no basis on which to think that this was voluntarily done?
And I think that, again, that there's a range of responses to relapse that are possible here, and I think taking away the ability to impose the condition and to have those consequences and that aspect of accountability available when sentencing someone with a substance use disorder can actually have a negative impact.
So could the judge not have done the same thing? I'm not talking about the second judge, not the final probation revocation hearing, but the first one. What happened here was the probation officer comes back and says, Judge, I ran the drug screen. The drug screen says that she's got fentanyl in her system. The judge immediately, there's no finding of a violation at this point. There's just basically probable cause of a violation, at least of something, right? She's either committed another crime or, she has, or even, well, okay. So then the judge says, okay, I'm really worried. I'm going to change the condition of probation. Is there any reason why the judge can't change the condition of probation at that point?
No, I think relapse would be a changed circumstance in which a judge could change the conditions to inpatient treatment.
Okay.
And again, the flexibility, I think that some of the circumstances...
Did you need to have a drug-free condition in order for the judge to be able to do that?
You would need to have that in order...
Why? Because you just said it has to be a changed condition, and if the judge says drug screen shows fentanyl, then that, I didn't understand that she had that in her system before. So I wouldn't have imposed, a date program. I would have said she had to be in an inpatient program. So changed circumstances, I'm going to change the conditions of probation. Could he do that?
Again, I would argue, I think possibly he could, but I think it would take away a lot of discretion in how to respond. And I think here there's actually a lot of kind of step-by-step process in which a probation officer took into account various circumstances, not just the positive drug screen, but also the fact that the probationer denied that she would test positive, and after she tested positive, denied drug use and stated that she didn't want to go into an inpatient program. So you have that kind of built-in discretion that the probation officer has in responding to a relapse, and I think that's important to preserve. And if you had a broad rule that all you could do is either have a treatment condition, which is either outpatient or inpatient, I think that would take away from the criminal justice system's ability to respond to addiction in ways that are based on treatment.
Do judges have information before imposing probation conditions in the ordinary course as to what, do they run drug screens of the person in advance to know what the status of the person is at the time?
I'm not sure. I think that's not in the record in this case, but I think that certainly is possible, and I think we can infer from how the judge decided regarding the disposition of this case that there's evidence about the substance use disorder. At least I don't know whether there's evidence that it was active at the time or not.
Now, here, the judge did not sentence her to 10 days in jail. The judge basically found probable cause and says, I'm going to hold you in custody awaiting a final determination, and once a bed came free, the judge brought the person before the court and then put her back on probation. But if the judge had indeed I know you're speaking about escalating sanctions, but the fact of the matter is there was only one count for which he was found guilty here today, correct? Found guilty, correct?
Yeah.
So if the judge had imposed after a final determination of probation, 10 days in jail, then that would have ended her probationary conditions. The judge did not have the authority to put her in jail for 10 days as a sentence for her final finding of probation, and then keep her on probation because the judge only had one count.
Yeah.
So how can how can a court do escalating sanctions when the law doesn't permit that?
I think that the escalating sanctions are discussed more in terms of the drug court context, and any decision to disallow drug-free or substance-free conditions would undermine the ability of drug courts to function based on those escalating sanctions.
The only way the drug court can do it now is the way this judge did it. Essentially, I'm going to hold you awaiting a final determination. That's the only way the drug court can do it now because of the limitations in law. Does that matter in terms of our analysis?
I don't think so, because I think there are other ways that discretion and flexibility are
Okay. Last question. If the judge here had done what the judge did not do, which was say, you have a violation of probation, you have a 2.5-year sentence that I have not imposed because I placed you on probation, I'm now going to sentence you for the underlying offense of larceny, and I'm going to give you 2.5 years in the House of Correction. Would that have been an abuse of discretion?
I think in this case, again, it would depend on the specific findings and circumstances, but I think, yes, it would be.
So you're saying that we should then say that a certain sentence can be an abuse of discretion? Do we have any case law that says that we as a court will evaluate sentences for abuses of discretion?
No, but I think you could rely on case law that says you could evaluate probation conditions based on
I'm not talking about
them.
probation conditions. I'm talking about a finding of a violation of probation and a judge's determination that he or she is going to now sentence the person on the underlying offense, which in this case was not a drug offense, but an offense of either of larceny over 250.
I mean, I think that, no, not that I know of, that I think
It's a lawful sentence.
it would be a lawful sentence, yeah.
And should we change that?
I don't want to speculate about that in this case. I don't think that's the question that this case raises, really, and that's not what happened in this
No,
case.
but-
Would we need something in the record that anybody has ever been sentenced to 2.5 years committed on one dirty screen? Because I did the drug court for 3 years in the district court, and I never heard of anything like that happening.
yeah.
And you can convert the 2.5 into, it's a split sentence. You can split sentence in the district court and change it to 2.5 in the House of Correction, 10 days to be served and balance suspended for 2 years.
Correct.
I mean, do we need a record that some judge has ever done anything like that
It
before?
would, yeah. I mean, that's why I say I hesitate to speculate and to say that this court should prohibit a practice that we haven't encountered in this context.
You talk about the fact that this is, she was punished not for substance abuse, but for her underlying offense. But the punishment in question had to do with her incarceration until she got the new in-treatment facility. And that happened prior to a finding of a violation.
Right.
So does there have to have been, so how is it that we're going to say that that was a punishment that was imposed for the underlying crime?
I think in this case, it's not strictly speaking punishment, and that's why I pointed out that the response to relapse was actually sensitive to its nature, in that the judge did not revoke probation and allowed.
Well, no, I know in the first instances when it wasn't when there was the second hearing, it was the first hearing when
Right.
this happened.
So,
And there
I
was
mean,
no
arguably-
finding of a violation, there was just probable cause to think something had been violated. And at that point, you could say she was incarcerated. She was incarcerated for something. Was it really for the underlying crime?
Well, the ability to incarcerate her based on a finding of a probable cause that she violated probation came from the underlying crime.
But
so-
did the judge in the first instance have the power to put her back in prison for the underlying crime, to
If
change
she
the sentence?
violated probation.
Well, the judge only had probable cause to think she had. That wasn't a final probation hearing. There was no final finding of probation, violation, right?
But the rules allow judges to hold someone based on the finding of a probable cause in certain circumstances, and arguably, the decision to detain Ms. Eldred in the particular circumstances of this case was not unreasonable.
Okay, thank you.